Thank you, Carol. That was really nice. Yes.
You can stand on behind the speaker. The microphone is on.
Will that be easier for
I
people,
think
or
it would be
am I okay
lots
with
of-
volume
Sure
wise?
would be.
Yeah. Okay, I'll do that. I was hesitant to want to stand up here, but okay. Feel very important. I want to grab a copy of that handout too, Carol, when you get around.
Right.
So I woke up this morning, I was like, what have I done? Like, this is such a confusing area of the law, and we're going to try and make sense of it. And then I thought about it a little more, and I was like, well, no, I've got the easy job, and you all have the hard job, because you have to come to a position on what the solution is. I get to just tell you about how problematic it is, and how messed up it is, and you have to make sense out of that. So good luck with that. So I have an easy job, is what I came to earlier today. So who's seen the position statements, kind of the explanations that the league has prepared for this discussion on money and politics? Carol and I were just talking that it hasn't been distributed, so I just wanted to check if people had seen that. Okay, so a few people. How many people have heard of Citizens United? How many people know which Bill of Rights provision is at issue in that case? Yeah, First Amendment, okay. I just want to kind of check and see where things are. So, feel free to interrupt with conversations on the topic that we're going through. If it's kind of a broader thing or it's going to take us off on a tangent, if you're willing to hold that till the end, we'll try and handle that at the end. But I'd rather you say, hey, wait, I didn't follow that at all. What'd you just say? Than to just be confused. Because we're going to try and build a progression. We're going to try and build a structure for thinking about how the First Amendment interfaces with election, with campaign finance law, and how that money and politics issue is playing out today. So I want to build a framework and a structure for us to work in, at the same time recognizing that it's a really messed up system right now. And so, that structure doesn't necessarily always fit. So as we go forward, if you're feeling like something's not making sense, you're probably not the only one, so please voice that and we'll regroup and move on. So what we're really going to talk about to start with is the First Amendment to the United States Constitution, the federal Constitution. We're not going to be talking about state protections of free speech and political speech and expression, even though we have those as well. But we're going to be looking at the federal First Amendment, and that'll play out as we get into it more. So the federal First Amendment comes from the late 18th century. I was trying to read up a little bit on that early history, and the things that it was clear that it addresses are two things that was prevalent in Britain. One was the licensing of publishers, that you had to get a license from the state before you could print things, before you could be the media. And people said, and we don't want that anymore. So that's one of the things that it addresses, that freedom of speech, freedom of the press. And then it also was addressing an issue in Britain that came from British common law, seditious libel. So you speak against the government, and that's sedition, and that's punishable. And it wasn't even a defense to say that it was true, because it was actually perhaps worse that it was true, because it was even more seditious if it was true about the government. So the First Amendment was definitely intended to eliminate the licensing requirements for publishers and eliminate seditious libel as a crime. But other than that, what exactly it meant, people aren't really sure. So from there, in the end of the 18th century, we've developed this very complex case law about what those handful of words in the First Amendment of the U.S. Constitution mean. And it's become one of the more complex areas of constitutional law. there's not really a framework for it. There's a series of questions that courts can ask, but they can jump in at all sorts of places. So the framework that we're going to use here is borrowed from the framework that deals with 14th Amendment issues of fundamental rights to equal protection and due process. But it's the same framework that I think will help us make sense of First Amendment, to the extent that we can put a framework into it. And I'm paraphrasing one of the leading constitutional law scholars in the U.S., Erwin Chemerinsky, who, I was looking at his book this morning, I'm like, okay, if he's saying there's no framework, that's reassuring, because it means that we're not just all really confused. So there's 4 kind of reasons for protecting free speech in our thinking about the First Amendment and why free speech should be a fundamental right. It should be one of these foundational protected rights that the government must show a very high standard before it infringes upon people's fundamental rights. So does everyone have a copy of this handout? So the top of it on the left side just lays out those 4 theories. The first one, number 1, is that freedom of speech furthers self-governance, that it allows people to criticize government without fear of retaliation, or so we're told. And that's a very central purpose of the First Amendment. It goes back to that seditious libel idea. The second one is that it aids in the discovery of truth. And I think in some way this is the theory that we're playing with the most as we examine election financing. The theory comes from, I think Justice Holmes is credited with this marketplace of ideas concept. So he said in this case from 1919 that the best test of truth is the power of the thought to get itself accepted in the competition of the marketplace of ideas. That we have free speech so that people can communicate and compete. It's really a free trade theory. I mean, Holmes was writing at the laissez-faire early 20th century, and that's how he frames it. Abrams versus United States, that case that he was dissenting in, is one of the first Espionage Act cases. It involved alien anarchists who were leafleting in New York, and they were charged with conspiracy in violation of the Espionage Act, and the court found them guilty. I thought that was interesting because the Espionage Act is very popular today with the Department of Justice. Yes?
So was he saying that if an idea is accepted by the populace, it must be true?
That we have this right under the First Amendment to share our ideas. We can put our ideas out there, and the ideas, this is kind of one of the places where it gets criticized, that psychologists will say, well, this marketplace of ideas kind of has that idea that you're pointing at, that, well, if it's the idea that society accepts, then it's the truth, but that's not necessarily how people work, So like psychologists are critical of the marketplace of ideas concept. And, I think they've got a good, you can pound somebody over the head with a bad idea, an untruthful idea, and they'll eventually believe it just by saturation. I'm not professing that that's actually how the brain works. But, so that's one of the criticisms of this marketplace of ideas concept. That's not a criticism I put here. There's another criticism, which is perhaps what we're getting to in this consensus process, which Lawrence Tribe, who is another constitutional law professor, describes there. So I put the quote down that, especially when the wealthy have more access to the most potent media of communication than the poor, how sure can we be that free trade in ideas is likely to generate truth? Right? I mean, that's what we're dealing with in elections. That does the fact that people have unequal ability to communicate get us to this place of not being able to get to the truth of a matter just by the ability to saturate media? Connected to that, I put in this image. This comes from a psychology study, but I pulled it from Mother Jones magazine where it was reprinted. So this image shows the top row is the actual distribution of wealth. You can see the different shades. So the top 20% of the US population actually has over 80% of the wealth. The second row down is what Americans think it is. What do we actually think that wealth distribution is? And we think that the top 20% of the US population has less than 60% of the wealth. And then the final bar is what would they like it to be? What would people in the United States like wealth distribution to be? And their finding from interviewing about 5,000 people was that generally people would prefer that the top 20% had maybe over a little over 30% of the resources. So much more of a equitable distribution, especially compared to what it actually is. The difference between what it actually is and what we think it is, I think, is very telling in that graph. So that's what we're dealing with, is this immense inequality in wealth, and how does that aid in the discovery of truth, to go back to this justification for the First Amendment. Number 3 and number 4 are different kinds of First Amendment justifications that I don't think we're dealing with as much here. Number 3 is about autonomy and personal self-expression. The case quoted here says, the First Amendment serves not only the needs of the polity, the political needs that we have, but also those of the human spirit, a spirit that demands self-expression. Some of the US Supreme Court decisions say that when somebody goes to a rally or a protest and they express themselves, that it doesn't really matter if anyone's listening to them. It's a self-actualization and a self-development process that free speech allows us to undergo. So that's another reason for freedom of speech. The fourth one is about fostering tolerance, and this is another controversial idea that free speech allows activities that we don't like. There's a recent book about the First Amendment called Freedom for the Speech We Hate. And so this idea is about that, well, it's tolerance of a desirable, if not essential value, that protecting unpopular or distasteful speech is itself an act of tolerance. And the reply to that is that, well, being tolerant of intolerance isn't required in a tolerant society. So that's perhaps more of a philosophical, maybe even a religious debate. I mean, I'm standing here at Unitarian Church, so bring that in. That, do we have to be tolerant of intolerance, and how does that play out? But that's another justification used to defend freedom of speech as a fundamental right. So, what does it mean for it to be a fundamental right? Yes?
I'm having trouble with number 2 because I always get nervous when people start talking about truth. And can you express that one without using the word truth?
I agree with you that there's a challenge there, and I'll back up and not directly answer your question, but say more about what the challenge is. That Justice Holmes is credited with being one of the leading theorists of a jurisprudential idea, so a philosophy of the law idea called judicial realism. And judicial realism is the idea that the law doesn't find the truth, that there aren't absolute principles of right and wrong. Those ideas are referred to as legal positivism, which is a different jurisprudential philosophy. Instead, Justice Holmes said that really the law is what a judge says it is. And that's what's right, is what a judge says it is. And how does a judge decide what's right and wrong? The judge wakes up, comes to court, and gets a hunch of, well, this is how I want to rule, and then finds the right legal theory in order to get there. So finds the right ideas that provide some kind of rational justification to get to the outcome that judge wants. So Holmes really blew apart this idea of truth, especially within the law, but yet in his dissent here in Abrams versus United States, he's saying that the marketplace of ideas helps us to get to the truth. So I'm not sure if he knows what he means by the truth. He wrote a lot and I haven't read it all, so we'll have to do that. Read more Holmes and figure out what that means. But yeah, I agree with you that there's a challenge there. What do we mean by the truth? Yeah. I mean, he was also writing at the time. I think there was a strong idea in truth and justice Those ideas kind of around the early turn of the century, truth was often used there, but I'm out of my department now. Is that okay? So what does it mean for something to be a fundamental right? For a fundamental right, it means that the government has a lot of restrictions before it's able to infringe on that right. That it's a right that we have that the courts say is so deeply rooted in American traditions or American society or in our politics that the government can't just pass any law that's going to infringe on it. There's a very strict test. That test is often called strict scrutiny, as opposed to lesser tests called intermediate scrutiny, or even less is called rational basis review. So we're dealing here with the most strict test that the court has come up with for a constitutional issue in order to decide whether a statute or a law passed by the legislature can withstand a constitutional challenge. So does that law violate that constitutional right, or does it not? What's the test for determining that? And that's the test that the court ends up using when someone challenges a rule from Congress or a rule from a state that limits spending on a campaign. The court is going to this fundamental rights test within the First Amendment free speech context. So what's the test? It's really a four-part test. So at the bottom of this first page, we're looking at the strict scrutiny analysis of a fundamental right. And step one, is there a fundamental right? No fundamental right? No problem, right? There's no infringement if there's no fundamental right. And I think it's important for us to remember that that's part of the test. Is there a fundamental right? The second part, is the constitutional right infringed? There might be a fundamental right and the government passes a law, but that law doesn't infringe on the fundamental right, so we're done with the analysis. There's no reason to go further because the fundamental right is not infringing, the law is not infringing on the fundamental right. So those are kind of preliminary questions before we actually get to the strict scrutiny test. The strict scrutiny test is numbers 3 and 4. So number 3, and let me back up. They're referred to in the law as an ends means balancing test. So what's the government's end? What's its purpose in passing the law? And then what's its means for actually achieving that purpose? So number 3 is the ends, right? So is there a sufficient justification for the government's infringement on the rights? What is the government trying to do by passing that law? What is the government trying to accomplish by passing that law? What's its goal? What's its purpose? Why? Right? That's really the question. And in a strict scrutiny framework, the government needs a compelling interest in order to justify infringement of the right. Well, what does that mean? Don't look at me, I don't know. Neither do the justices on the court. They say it's a truly vital interest. That's one way of defining it, but well, what does that mean? I mean, so they're always messing around with, well, what is a compelling interest? We've agreed since this framework was established in the 1930s that there needs to be a compelling interest. But what does compelling mean? Different justices are going to take different views of that.
When you talk about framework, are you talking about this strict scrutiny? Is that a framework?
That is the framework we're working in, is strict scrutiny analysis, to determine whether the First Amendment freedom of expression or freedom of speech has been infringed by a law, and specifically the laws that we're going to look at, although I'm not going to cover in a lot of detail, are laws concerning who can spend money in elections. Let's see. I'm looking at the time, and where are we at?
We're good.
Yeah?
Yeah, we've got half an hour to go.
Okay.
Easily half an hour.
Yeah, easily more. We need it.
Okay, great. So, compelling end. And then number 4 is the means part of the test, right? So how are you going to achieve that end? So are the means sufficiently related to the purpose? So what the strict scrutiny test requires is that the government must show that the law is necessary, right? Not just like, oh, we'd like to do it this way, but there's other ways we could do it. Not like, oh yeah, this seems like the best way, but we don't really have to do it. It's necessary to achieve the objective, to achieve the justification, the end, right? And there's this other requirement that it has to be basically no other less restrictive ways to do it. That this is really the only thing that the government can do in order to achieve its compelling purpose. Good luck, right?
I've got a couple of examples, yeah.
Yeah.
Like in the context that we're, with campaign funds
Yeah.
before.
Yeah.
Because-
Let me finish this and I'll give you an example that passes the test.
We have a whole thing on the back.
Oh, sorry about that. I'll give you an example that passes the test,
Okay.
and then we'll go back and we'll look at how so many laws have failed the test, if that's okay.
Sure.
All right. So just to draw a distinction, we're here at strict scrutiny. Compelling and a narrowly tailored, necessary means of achieving that end, right? Just to give context, the rational basis test, which is when a fundamental right is not involved, requires the government to have some reasonable basis. It can even be something that the government, so the end is reasonable basis. Like, the government can even make it up afterward, right? It doesn't have to be like there in the law. Congress passes a law and they don't even know why they passed the law, they just passed it. And then afterwards somebody sues and says, hey, that violates something. And the government attorneys can say, oh, well, this is why we did it. Now we're making it up afterward. The courts say, no problem. That's rational basis review. It's easy to pass. And then there has to be some relationship. That's it. There just has to be some relationship between that reasonable basis, that end, and the means by which Congress is achieving that end. That's the typical test. When we're dealing with a fundamental right, we're dealing with intermediate scrutiny, which is kind of in between, or we're dealing with strict scrutiny. And strict scrutiny is this compelling, like truly vital interest combined with means that are narrowly tailored and necessary to achieve that end. So we've gone a very, very tough way for people to actually pass that law.
So the framework sounds reasonable in general. You mentioned that it was developed during the 1930s. Was there a particular context that led to the development, and was that development within the Supreme Court?
Yeah, so a lot of the constitutional law stuff that we deal with comes from the 20th century. That in the 19th century, there wasn't really a lot of use of the Bill of Rights and kind of constitutional law happening then. So at the beginning of the 20th century, we see courts kind of playing with these ideas of fundamental rights. What happened in 1937 was the US Supreme Court decided a case called Caroline Products. I forget the full case name. And in it, they inserted this footnote that said, hey, when we're talking about a fundamental right, we're going to use this like strict scrutiny analysis, and when we're talking about just kind of any other constitutional analysis, we're going to use this rational basis review. And they laid out this idea of different standards of ends means analysis for deciding whether a law violated a constitutional right. So that decision, that footnote, became basically the framework for the entire progress of First Amendment law, not all of it, but a lot of it, and then 14th Amendment law concerning due process and equal protection. That almost every time we look at those, whether a law violates one of those three constitutional provisions, we're using an ends means test that is one of those levels of scrutiny. So what attorneys argue about is, well, which level of scrutiny should it be? Should a gender inequality prescribed by law be strict scrutiny, or should it be intermediate scrutiny? Right now, that's intermediate scrutiny. If it was strict scrutiny, well, how would that affect laws that benefit pregnancy? Right? I mean, could you have a law that benefits, that gives more rights to somebody who's pregnant at work? And could Congress prescribe that law? You're differentiating and you're discriminating then by pregnancy. Well, who can get pregnant? Women can, men can't. So should we have strict scrutiny analysis for whether that law violates equal protection, or should we have intermediate scrutiny analysis? That's kind of one of the first questions. So one of the first questions is, what gets strict scrutiny? What gets strict scrutiny are fundamental rights, specifically First Amendment stuff, race, nationality, ethnicity, national origin to some extent, but not necessarily other characteristics that people have: sexual orientation, gender expression, gender, disability, class. Class doesn't even get intermediate scrutiny. I think class is rational basis review. But we're kind of off field in this. So that's kind of the framework that we're dealing with when we're talking about strict scrutiny, intermediate scrutiny. It's a whole class in law school. Okay, so we've got this ends means test, and we want to find, well, who can possibly pass this ends means test? I mean, because this is a really high standard for the government to pass a law that then can withstand a First Amendment challenge as that law not being a violation of somebody's First Amendment free speech.
And when you say the government, are you also including the Supreme Court? I mean, when Congress passes a law and then we're going to scrutinize it, is that the Supreme Court also in there, or is that Supreme Court's up here and Congress is down here passing laws?
Well,
and then the law gets challenged to
yeah.
the Supreme Court.
So Congress is the legislature for the federal government. You know, we have the state legislature here and the state legislatures for all. So the legislatures are generally passing the laws. So legislatures in this framework that we're dealing with campaign finance are passing these campaign finance laws. So then somebody says, hey, that violates my free speech because I can't spend my money how I want. And so they challenge the law and the legal validity of the law. They say that law is unconstitutional. And then the courts, well, they go to the court, and the court decides what laws are constitutional, what laws are not constitutional. That takes us way back to Marbury versus Madison, 1803, that the courts get judicial review. That ultimately it's the courts that get to decide what the Constitution means. You know, that we have this language, First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. What does that really mean? Well, the court gets to decide in our system of law. So these are, what we're dealing with are campaign finance laws passed by Congress or state legislatures that then go to federal court because somebody says, this violated my First Amendment rights, so federal court gets to hear it because it's the federal Constitution at play. And the court, the U.S. Supreme Court, has been saying, yeah, campaign finance laws violate First Amendment rights because of that strict scrutiny analysis and the way the court's been interpreting it. But they haven't always said that. So if you flip the page over to this long list of cases and go to the very bottom, in April of this year, in a 5-4 opinion, I'm going to make you try and guess which justice. In this, at the very bottom, so Williams-Yoli versus Florida Bar. This is a judicial candidate, so somebody running for judge wants to personally solicit campaign funds, right? The Florida has a law that says judges can't do that. You as the judge can't personally solicit campaign funds. And Williams-Yoli says, oh yeah, I can, because, you know, free speech, right? So this lawsuit comes up, it goes to the U.S. Supreme Court, and April of this year, the U.S. Supreme Court said, it wasn't April Fool's Day either. The U.S. Supreme Court said that, well, is there a fundamental right? You know, let's go back to our analysis. Is there a fundamental right? Well, yeah, First Amendment right to talk to people. I mean, to say, hey, give me money, right? That, the US Supreme Court says that's a First Amendment right. Is the right infringed? Well, yeah, this person can't do it, right? He's not allowed to do it because of this Florida law. So the right's infringed. Okay, so government, tell us what your compelling interests are, right? What are your ends? What are you trying to achieve by this law? And what the government said was that it's trying to promote the state's interest in protecting judicial integrity. That we don't want people to think that the courts are biased. We don't want people to think that the courts will play favorites, that the courts will do things for people who donated to them and maybe they won't do the same things for people who don't. We want the courts to appear unbiased. And also that there needs to be public confidence in the impartial judiciary. Okay, I kind of just said that already. But that the courts need to appear to be neutral. And the US Supreme Court said, yeah, that's a compelling interest. That is one of those truly vital interests that meets that high standard for being a compelling interest. Okay, great, you passed that test, government. Now the next part, part 4, final part is, are your means narrowly tailored in order to not harm other people's speech, but only defend those vital interests, those compelling interests about keeping the judiciary neutral and the integrity of the judiciary. And the court said, although I didn't really put it in here, that yes, the way that the Florida law did it was narrowly tailored. So the Florida law stands. It is good law as far as the First Amendment is concerned. It doesn't violate that judge's First Amendment rights, nor does it violate the people who are listening to that judge, because you have a right when you're listening as well. So I was a little surprised, actually, the US Supreme Court, that we've been saying, oh no, they're striking down election laws left and right. I mean, you have unlimited spending and all that. Well, no. If you're a judge in Florida, you cannot personally solicit funds from potential donors.
What for?
It's true. So the 4 that don't think that are 4 that you would expect not to think that. But who's the one who switched?
Kennedy.
That's what you think. That's what I thought first.
Don't tell me it was Robert.
It was Robert. Yeah, it was Robert.
Kennedy was over there.
Kennedy was one of the 4, one of the 4 dissenters. So for folks who don't follow the U.S. Supreme Court like a football game, there's these 4 liberal judges and these 4 conservative judges, and then Kennedy, who's kind of a conservative judge, but he's often seen as the swing vote, right? So that's why this one's surprising, because it's 5-4, but it wasn't Kennedy who swung with the 4 liberals. It was Roberts who came over, and who knows what his reasoning was.
Could be the appearance of the judiciary. He cares about his legacy.
He does.
Yes,
Yeah. That's an analysis for why he let the Affordable Care Act through.
Right.
Yeah. But he's got a tough job, trying to
Poor guy.
do what he's doing. Okay, so that is the one case on this list that upholds election law. Everything else helps to build a framework for how we got to where we're at. So I'm going to try and briefly run through it, and I think that's okay, because really understanding this ends means framework is the core, and how these particular decisions came down isn't necessarily the important part. There's these awesome readings of the League of Women Voters, U.S. National Office, headquarters, came out with, and I was reading a lot of them yesterday and today, and they're amazing. They're really good at laying out what's the framework, what's going on in these cases, at a level that I think is awesome, is really great. I'm saving them, and hopefully it's okay to share them with other people. But you'll get that shortly, perhaps, and so that'll help to provide more of a structure. So read the homework. Don't just rely on what I say, because this is kind of covering the big picture legal concepts, not the nuts and bolts. So I want to go back almost 200 years to a case where the King of England had chartered Dartmouth College, right? So here's a charter. You get to go forth in the king's name and do this thing, this educational project of Dartmouth College. Just the same way that Massachusetts Bay Company, Hudson Bay Company, all these various crown corporate colonies were started, in the 18th century. Dartmouth College was started too. There was a little row between New Hampshire, this new state of New Hampshire, and the Dartmouth College trustees, and the legislature of New Hampshire said, why don't we revoke that king's charter and take over that school and make it a public university, right? So they tried, and the US Supreme Court said, no, you can't do that. That even though this university is chartered by the government, right? Just like corporations are, if you want to form a corporation, you apply to the state of Washington and say, I'd like to form a limited liability company, or I'd like to form a business corporation, or I'd like to form a nonprofit corporation. And the US, or the state, Secretary of State issues you an Articles of Incorporation. This is your charter. This creates that legal being of the corporation. Even though the state creates that legal being of the corporation, once a corporation comes into existence, said the US Supreme Court in 1819, that corporation then becomes kind of like a co-equal with the state. It's more like a contract than it is a principal-agent thing. They're co-equals. They're not hierarchically related. So the contracts clause of the US Constitution forbid the state of New Hampshire from taking away that charter from Dartmouth College. And this case really laid out an explosion of corporate law in the United States, that corporations are not subservient to the government, but they're now co-equals with the government. We go forward, we go through a lot of tumultuous 19th century history and the Civil War, and we get the Civil War amendments to the US Constitution that ended slavery. And the key one, though, for our purposes today is the 14th Amendment, equal protection due process.
Back in 1819, were there business corporations?
Yeah, and the first private bank in the US was from 1780. And there's a great book at the North Olympic Library System called Taming Democracy that looks at the history of the 1780s and the role of the first private bank in all the crazy stuff that happened between the American Revolution and the US Constitution. Yeah.
But corporations had limited charters for 20 years, for the first 100 years of the country.
Yeah, thank you. So corporations, the state issues the corporate charters. So initially, you want a corporate charter, you have to go and the legislature passes a special act to say, now we're creating this new corporation, now we're creating that new corporation. And they were very narrow powers. Some of them expired, right? Like the corporation doesn't have perpetual life. Initially, corporations couldn't make donations. People were like, yeah, wait, if the corporation gets to make donations, then we're beholden to the corporation to provide charity, and we don't want that. So corporations can't make donations. So corporations were lobbying to kind of reduce these restrictions until we're finally at the stage now where we have general business corporations that exist forever for any lawful purpose and can do basically any lawful purpose, right? It wasn't that way through most of the 19th century, and I appreciate you reminding me to mention that. So the question became, out of the Civil War amendments, and specifically the 14th Amendment, of, well, who's restricted by the 14th Amendment? Who can, did I say that right? Yeah, who's restricted by the 14th Amendment? So whose activities are limited by this requirement of due process and equal protection? And what the US Supreme Court said in the civil rights cases, 1883, the second one down, is that the 14th Amendment limits individuals. I'm sorry, I just said it completely backwards. The 14th Amendment limits the government because it says, it doesn't say no state shall, it says, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, Nor shall any state deprive any person of life, liberty, or property without due process of law, that's the due process clause, nor deny to any person within its jurisdiction the equal protection of the laws, that's the equal protection clause. So the US Supreme Court said no state shall means that these limitations go to the state, go to the government. These are limitations on what the government can do. They're not limitations on what private people can do, including corporations. So corporations are not limited by the constitutional rights that are in the 14th Amendment, and by extension, all of the constitutional rights that are there. Because basically the 14th Amendment is the tool that establishes the Bill of Rights to limit state activity as well. Because initially the Bill of Rights only limited the federal government's activity.
So does one of these cases on the back here actually claim that corporations are people?
You've jumped to the next one. All right. So corporations are not limited by the restrictions in the Bill of Rights. They're not limited by the restrictions of constitutional rights. Corporations weren't happy with just not being restricted, because this was the time, these cases came out of like people tried to use civil rights law in order to desegregate hotels in the South, stuff like that. And that's what the civil rights cases in 1883 were about. It was saying, no, you can't do that, but those are only limitations on the government. Well, corporations then didn't just get to say, okay, well, we can do whatever we want. They also said, well, we want the protections that the Bill of Rights provides as well. So that whole history and exactly which case said that is really unclear. I cited this case, Santa Clara County versus Southern Pacific Railroad Company, because it does have this express text where the court doesn't want to hear whether or not corporations are persons under the 14th Amendment, and thus get the protections of the 14th Amendment. We all agree that it does, right? There's a whole theory about whether or not the court actually said that in that case. It doesn't really matter. It's so firmly embedded in our law now that it doesn't matter whether it came from that case or another case.
So that's the sentence that makes corporations have the same rights as people under the Constitution.
But it's not just that case. There's so many pieces that say it. Yeah. Yeah.
Well, that was written by the court clerk, though, in the head notes. And just because it set a precedent doesn't mean it's right. And I don't know why we have to keep following it.
Because the court keeps ruling.
Well, part of the reason why I've gone back 200 years in this is because when we're trying to figure out how do we solve this problem of campaign finance reform, I think we have to ask those sorts of questions and say, well, how deep do we have to go? And I'll get back to that, and I apologize if I'm going to run over. Is it okay? Yeah? Okay. So let me get back to that, because I think how deep we have to go is really key to this. And that's not something I'm going to tell you, like how deep we have to go, but just say, like, that's a question for the league to figure out. Okay, so corporations get the protections in the 14th Amendment, and the rest of the Bill of Rights. They don't have to abide by those restrictions, only the government does. Then we fast forward almost 100 years in this timeline, skipping a lot of great history, and we get to our first campaign finance case in this series. So Buckley versus Valero is the case that a lot of people will say stands for the idea that money is speech. Because the court said that restricting the amount spent on political communication necessarily reduces the expression. The expression is the speech. So if you don't spend as much, you don't speak as much. And that's not what the First Amendment is about. The First Amendment is about the marketplace of ideas, right? The solution to one person speaking a lot and then drowning out somebody else is not to make this person speak less. And that's one thing that the court's been saying. Like, you can't just make one person speak less. That violates their First Amendment rights. You can find other ways to make this person speak more, but you can't have this person speak less. It's about the marketplace of ideas. And, having, this, I think they imagined a stock exchange and like, rah, all over. So 2 years later, they came up with First National Bank of the Lodi. which I probably don't pronounce right, which firmly said, okay, well, corporations also have these First Amendment rights to make campaign contributions, right? So in the late 70s, we have money is speech and corporations get to speak, especially when we're talking about campaign stuff. So while Citizens United has been the cornerstone for people to reevaluate this issue from a First Amendment perspective, it goes way back. And I think Citizens United really just kind of solidified the pieces together. So then in the recent past, so these last 4 cases, we have kind of a precursor to Citizens United in 2007, Federal Election Commission versus Wisconsin Right to Life. 5-4 decision, you would be able to guess how it split. So there was this decision that upheld a lot of campaign finance in 2003, which was McConnell. And this case didn't expressly overrule McConnell. It said that McConnell held that the express advocacy of a candidate to his opponent by a corporation shortly before an election may be prohibited, along with the functional equivalent of such express advocacy. We have no occasion to revisit the determination today. We're not overruling McConnell. But when it comes to defining what speech qualifies as the functional equivalent of express advocacy subject to such a ban, the issue we do have to decide, we give the benefit of the doubt to speech, not censorship. So we have a majority of the state Supreme Court in 2007 calling campaign finance laws censorship, right? Very provocative language in this case that basically is a 3-year prior precursor to Citizens United, right? They're saying that when we look at campaign finance law, we give the benefit of the doubt to the speech. So they're going to be using a very strict standard. They're using this strict analysis that we talked about earlier, and that's where they're going with their majority opinion. And then we get in 2010 Citizens United, right, which basically overturned an earlier case, Austin from 1990, which was Thurgood Marshall, one of Thurgood Marshall's last cases, because he left the bench around 1990. Should be and is now overruled. We return to the principle established in Buckley and Bellotti that the government may not suppress political speech on the basis of the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations.
Well, they seem to be equating speech and money. I mean, speaking is one thing.
But how much?
Money, where is the money part of it? I don't think anybody wants to abridge.
Yeah, so to get that, we have to go back to Buckley versus Valero in 1976.
They just
So,
undid.
yeah, what they said, and the part I quoted after citing the case, is this court has never suggested that the dependence of a communication on the expenditure of money operates itself to reduce to the exacting scrutiny required by the First Amendment. One of the things here is that what the court decides is very political, right? And they're saying, well, look, they want to get to this outcome. I mean, I'm going to speak like Justice Holmes here as a legal realist. Like, they want to get this outcome of money as speech. So they say, well, look, you know, like, we've said that you write a letter, that's speech. You send it in the mail, that's speech. Well, the fact that you had to send it in the mail and pay the postage doesn't make it less speech because you paid money for it. So, you know, if you sent 100 letters, well, that would cost more money, but that doesn't mean your speech isn't more protected because you have to buy more postage. So your speech is protected regardless of whether you have to spend money to exercise the speech. That's their reasoning. I'm not saying it's right. I hope it's not.
I see what they're doing, though. They're actually subordinating money as a means to speech. And so as long as your speech doesn't matter, the money.
Yeah, it doesn't matter if you have to spend money to speak. The point is that you're speaking, and your speech is protected. That's a good way of framing it.
But there's the compelling interest of a level playing field.
Yes. So these earlier cases that we see overruled, like McConnell and Austin and some of the other ones, they're saying that. They're saying that there is a coercive, corruptive power of having somebody speaks so much more when we're talking about an election. It's undue influence, yeah, and those cases said that that is a compelling interest. So the compelling interest, what's the compelling interest, right? The compelling interest is the corruption that the political process gets when people say, it doesn't matter who I vote for, it's the money that's going to speak. It doesn't matter who I elect, because whoever can contribute to them are the people who they're going to listen to once they're elected. And the court, in a number of the decisions, which I'm not citing here because these are the decisions that are creating the structure that we now have to contend with, but in those earlier decisions, in kind of the, well, some of those 1970s, 1980s, 1990s, early 2000s, the court said that that corruption is a compelling interest. Where has the state Supreme Court gone with that, though? We get to McClutchin, the second from the bottom, April of last year. And the court said that integration and access are not corruption. Okay, so what's the compelling interest? The compelling interest that justifies campaign finance laws that infringe on First Amendment rights is corruption, right? But the court has now said that integration and access, in other words, I have more money, I get more access.
It's ingratiation.
Ingratiation.
Thank you. Ingratiation, sorry.
Which is very different.
It is very different. Ingratiation and access are not corruption. So the compelling interest, corruption. But the court said compelling interest is now very narrow. It has to be quid pro quo.
Exactly.
In this for that. Hey, I give you $1,000 and you vote this way. That sort of thing. It's sometimes sad how little money they have to get donated in order to vote certain ways. Anyway, but that is basically what corruption means now. And that the fact that somebody has more access, according to the court, is not enough. So when we go to that compelling government interest, the government used to be able to stand up and say, Your Honors, we have a compelling government interest because the people no longer trust the political system when they see that money speaks louder and all this stuff, right? And the court now says, sorry, the only corruption argument that we're going to listen to is quid pro quo, this for that corruption. And other than that, where's your compelling government interest? And in these recent cases, with the exception of this one earlier this year, the government has not been able to show a compelling interest that a majority of the state Supreme Court recognizes. So.
It almost seems to me that it's a form of bribery if a corporation gives hundreds of millions of dollars to a candidate and expects them to always vote in favor of that corporation's interests. I understand that the Supreme Court saying that the money has nothing to do with it and it's free speech, but when you give somebody money to do what you want them to do, isn't that what bribery is?
They've addressed bribery in some of the cases. I'm not remembering specifically what the court said about it, but they've generally said, no, this isn't actually bribery. And especially with the super PAC stuff, because, well, that money isn't going to that candidate, so how is there a bribe? Hello? I don't see a bribe. Do you see a bribe? Justice Souter? No. So 5 of them don't see bribery. 5 of them see that corruption is only quid pro quo, and that there aren't these other larger issues. The League has, one of these papers is this amazing paper about the research that's going on about corruption and the various ways that corruption works. It's really good. So that's the issue. So let's go back to our test on the other side. And this is where I think it's important for us to say, well, how big or small a view do we want to take of the problem? Is there a fundamental right? Some of these cases concern individuals making campaign donations. But a lot of them, and really where the bulk of the money is in corporations making campaign donations. So is there a fundamental right? Well, right now there is, because corporations have free speech rights. So if we say...
But don't we have laws that an individual can only donate so much to a campaign.
Not anymore.
I thought I just read that.
McClutchin
It's like $1,200 or something, it's a big
Yeah.
number.
McClutchin did some of that. It's possible some of those laws might still be around. I wasn't getting into that level of detail, so I can't answer it. So is there a fundamental right, right? If we think, well, maybe we intervene in the system in order to create campaign finance law by going at that element of the test, is there a fundamental right? Well, that means questioning whether corporations have rights under the US Constitution, right? And that's where that goes. Second point, is the constitutional right infringed? Well, that gets into some of these issues of, well, okay, say a corporation has constitutional rights, but campaign finance laws don't infringe upon those constitutional rights. We're separating those things apart. There's intervention there into the system. Step 3, is there a sufficient justification? Right now, the justification that the court sees generally is this corruption. And, well, corruption has to be quid pro quo. So, according to the current majority of the US Supreme Court, it's very difficult for the government to prove a compelling interest that is that kind of vital, necessary, compelling interest that allows the law to have a sufficient end in order to be valid. So that's an area where the court can define compelling broadly or narrowly, and it's really those justices deciding. And then the fourth one, are the means sufficiently narrowly tailored? You know, again, the court can decide, well, what is narrowly tailored going to be in this context? But depending on how much we want to get into this, we can look at, well, can we create a sufficient compelling interest for this particular law? And is this law particularly narrow tailored? And so we can play it at that game with number 3 and 4. And we can also play it at the game of, well, should money be speech? And should corporations have constitutional rights? That's dealing with numbers 1 and 2 of the test. So there's various ways to approach how this test works and what is needed to be able to create laws that survive this test in the campaign finance arena. And it kind of depends on how deeply we want to go into this system that's created the current state of campaign finance law.
Didn't they have a case after this one that was either Montana or Colorado where they had a law about you couldn't give more than a certain amount? And it was based on a history of rampant corruption, and they overturned the law. And I'm wondering on what grounds did they do that, since there was this history of corruption?
Yeah, that's American Traditions Partnership versus Western Traditions Partnership, 2012, I think. So Citizens United came out in 2010, and in Montana, they've had this campaign finance law like way back to the beginning of Montana. Montana's got some really progressive laws. Go Montana. And so in Montana, they ran this case up. The state court system and the Montana Supreme Court said, yeah, this is a valid law because of the strong tradition against the corruption. And then the people who are trying to overturn the campaign finance law in Montana got the U.S. Supreme Court to hear the case. And I was going to include it, but the opinion is like one paragraph. It says, see Citizens United, basically. I mean, that's all they needed to say, is see Citizens United. Like, we decided this, like, go home. That it's not only laws passed by Congress that are subject to the limitations of the First Amendment, but also laws passed by the state legislatures are also subject to limitations of the First Amendment. So that case, I was almost going to put it on, but it's so short, it's kind of not really worth it.
Is equality a compelling interest?
If we can frame it that way.
Yeah, and if you had some type of campaign finance law that said, you put it in a pot and it's equally distributed.
So, yeah, I think getting to the mechanics of it is then the question of, can we come up with a mechanism that survives this test? And that's potentially one way to do it. I'm going to leave those details to you, though. Yes?
There was another case that had to do with the accumulated donations of a very wealthy individual. At one point, there was a cap cap on what wealthy individuals could give. And at some point, that got overturned as well, right? Henry, you know, how much could he give in total was the question.
I think that's McClutchan,
That is my question.
yeah. Yes.
I've heard just recently that there is a state that is putting out, or maybe it's a city, I'm not sure, but there's an attempt to give citizens a certain amount of money. In Seattle. Yes,
Yeah.
and the citizens that now can vote with their money. In other words, if you can't beat them, join them. You know, with that, now, do you think that will be contested?
I was talking with a lawyer from Seattle, and he was asking me what I thought about that. I was like, I'm sure somebody will contest it because it's based on a tax increase for your property tax, and who wants that, right? So there's a tax increase, it goes to a voucher, and then everyone gets a voucher, and then they get to decide which candidate their voucher goes to. That's my understanding of it, but I haven't read it. I imagine somebody will challenge it, and we'll see where it goes. It'll take a number of years for it to be decided. In the very back, in the back.
Oh, that was actually my point, that Seattle had just passed in November.
Yeah.
This last election, this law, and I was wondering if we think that that's going to be upheld. We'll wait and see.
No, it's got to be challenged first.
Yes.
Didn't the Supreme Court already say that Arizona public financing of campaigns is illegal? I think that was a recent decision.
Yeah, I didn't read that one, so that's something to look at. So I'm going to leave the nuts and bolts of it to you, because you've got the framework. So basically, you have to be able to survive this First Amendment test and get past that. Yes?
Have you looked at what other countries have done in terms of corporations and how they treat them, and whether they are facing some of the same things that we're facing with our Supreme Court?
Not to the level that I can speak specifically about it, but it's generally a similar system. But let's talk afterward, because I've gone over my time, and I want to make sure that there's enough time for everything else. So I'll leave you with a joke that's relevant to is how many people does it take to amend the U.S. Constitution?
5.
5, why? Yes. So we're dealing with 5-4 decisions of the court. And I think there's one of the League of Women Voters publications that's part of this consensus process that talks about this issue of how does the U.S. Constitution change. And it's great because it talks about kind of the real politic of it, that it's not just, 37 states ratifying by a 3/4 majority constitutional amendment, but also the U.S. the Supreme Court and the composition of the court changing over time. So it's another way to change the U.S. Constitution, and this history that we just looked at shows that they do change the U.S. Constitution over time. So thank you so much. It's a lot of fun.